We were talking about this interpretation coming from the Department of Education. Well, the Equal Employment Opportunity Commission on Tuesday, the chairwoman unilaterally issued a, quote, technical assistance, end quote, document purporting to apply the Supreme Court's decision in Bostock versus Clayton County. Now, we were making reference to this earlier, Department of Education taking the same case. It was a Title VII case dealing with employment law. In that case, they were trying to apply it to Title IX educational law. But here in this case, this technical assistance takes the court decision way beyond what the court said in that opinion. In fact, going beyond what the court explicitly said it did not do. Joining me now to talk more about this and what can be done, Roger Severino, Senior Fellow at Ethics and Public Policy and a former Director of the Office of Civil Rights at the U.S. Department of Health and Human Services under former President Trump. Roger, welcome back to the program.
Glad to be back, Tony.
All right, can you tell us more about this guidance and how it is going beyond the intent of the Bostock case?
Yeah, and I thought these days were over where law was made by the stroke of a pen and a phone call under the Obama years, but apparently under Biden, we're back. The EOC, just the chairwoman, just her alone, issued a document that purports to apply Supreme Court case law to something that doesn't actually say it does. You cannot, as a commissioner alone, rule for the entire EOC. That's why you have multiple commissioners on that board. But Charlotte Burrows, the chair, went out of her way to say that it applies in a whole range of circumstances with respect to pronoun usage, with respect to shared bathrooms and shared locker rooms. And this actually happens in the workplace. Think about firefighters and their facilities, or any facility that has a gym. It's going to be based on a person's self-declared gender identity as opposed to their biological sex. And the Supreme Court decision in Bostock, which I disagreed with, Gorsuch, that was not his best moment, did not go that far. This is executive overreach that we have not seen since the Obama years.
So this is like creative interpretation, not to be confused with creative dance, that they're making this up based upon the Bostock decision. It wasn't there, but they're running with it. And I wanted to bring out that point that you made about the way commissions work. I just finished, I served as chairman of the U.S. Commission on International Religious Freedom. I did not have the authority as chairman to make decisions for the entire commission. I had to get the other commissioners, which is a bipartisan commission, to sign off on those. How can this be legal?
It's not. That is the issue. And if you read it closely, she dances around this precise issue. She says this is guidance and it's merely restating things that had happened in the past. That's just incorrect. The Supreme Court had not ruled based on any other prior guidance, and the commission is free to reject it or adopt it. That's why you have elections. That's why you have new commissioners. They can take a new position. They never went that far before. This is applying it to all employers under Title VII, when the Supreme Court specifically reserved all sorts of questions. It was limited to hiring and firing. It didn't talk about religious freedom and religious accommodations. It said that's for another day. It didn't get into pronouns. And in fact, this guidance goes so far, it says it's about gender identity, when the Gorsuch decision only spoke about transgender status and actually presumed male and female as a biological binary. They're just throwing this aside and saying it's whatever you want it to be based on your self-declared gender identity. That's nowhere in the decision itself.
So, Roger Severino, because this was done in a way that is beyond the limits of the law, as we said, the commission did not decide this. The chairwoman of the commission did it on her own unilaterally, which she has no authority to do. Would this not be susceptible to a lawsuit by businesses that would fall under the EEOC?
Oh, yeah, certainly. And again, this reminds me of the Obama years. There was so many times that people who were worried about their religious liberty and the proper application of the law sued because the Obama administration issued guidance that actually tried to change the law without following any real process, no public input, et cetera. So yes, they are absolutely vulnerable, but they want to have it both ways. They want to say that this is merely guidance, but watch out, if you don't follow it to a T, if you use the wrong pronoun, we're going to go after you with enforcement action. And if you're a small c conservative business who just wants to provide a product or service, you're going to take the very conservative route, and you're going to have your lawyers telling you, be careful, treat this as the gospel truth, as the law. That's the way to stay safe. And that's just another form of bullying.
Yes, absolutely. Absolutely. They want to force everybody to play along with their lawlessness and their make-believe. Roger Severino, thanks so much for joining us. I know you wrote a piece on this. I think we have that listed on the website. Good insight into this, I wouldn't even call it a decision. I would just say this action by the chairwoman of the EOC. Roger, thanks so much for joining us.
Thank you.